Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Pereira. The Supreme Court Collegium has decided to make public all its decisions regarding judicial appointments in the future. The Collegium will also ascribe reasons for the decisions. A resolution passed on October 3rd, available on the Supreme Court website, said. Now, the resolution, an administrative decision by the 5 senior-most judges of the Supreme Court, including the Chief Justice, is available on the Supreme Court website, along with 2 other resolutions appointing a few judges to the Madras and Kerala High Courts. The move to make collegium decisions public is being hailed by lawyers and activists, calling for more transparency and accountability in the appointment process. On this edition of The Big Picture, we will discuss reforms needed in the judiciary. Joining me on the program today are Justice R.S. Sodhi, former judge of the Delhi High Court; Satya Prakash, legal editor of the Tribune; Afzal Wani, professor of law, Indraprasth University, and we'll also be joined by Sorabjee, the former Attorney General of India. Thank you to all my guests for joining me on this edition of The Big Picture. Justice Sodhi, I'd like to begin with you. Of course, lawyers, activists and, the general public have hailed the decision of the Collegium to make its decisions public. But what about the candidate, what about those whose candidatures are rejected? Isn't it a blow to them?
No, you see the position the judiciary holds in the constitution and in the minds of the people. It is very essential that it be above all controversies. Now, this was a long called for cry by the people, that the collegium make its decisions more transparent. Acting upon that, the court has wisely, I think, taken this decision. And those that are left out, of course, there will be repercussions, but I think they can yet be a method by which the ones that have been rejected, their reasons for rejection can be withheld. I think so.
Okay. Fair enough. All right. Let me bring in my other panelists as well. Professor Afzal Wani, as far as this decision is concerned, do you think that is going to lead to further judicial transparency?
Let us see first the decision has come, or this putting things on the site. It's basically in response to a demand for transparency. I believe that the first step should have been taken as the clear criterion. What should be the basic things on which a person is to be judged? Now, without doing that, you will randomly put something that he was not taken, not found, it creates a problem. So might be, if we are clear about the criterion, maybe somebody would himself or herself opt to be out, and therefore it may not come to that stage. I believe that we are going by knee-jerk reactions in different things. Judiciary has to build its image. Collegium is all right, but they will have to go stepwise about the things to build its image. And maybe this has to be again thought about. What are the considerations which were there? And then only it should come at a stage where you are very clear about the criterion and it is not fulfilled.
Okay.
That should be there. If we are not very much clear, it is subjective. Then at that stage, when you are doing it, is really stigmatizing somebody. And he may not be then able to do the present job also well. And anybody can say anything about any person, wherever he is, maybe a lower court or a higher court. So that way it carries that kind of problem with it.
Okay.
We'll have to reconsider it, and then we have to do it. But how? And
a step-by-step process is required, is what you're saying. This is just a knee-jerk reaction.
It should be a well-considered kind of thing, not like a knee-jerk reaction.
Okay, sure. Let me welcome Soli Sorabjee, former Attorney General of India, to the program right now. Mr. Sorabjee, what do you think of the decision of the Supreme Court Collegium to make its decisions about judicial appointments public?
I think it's a good decision. It brings out transparency. It removes the air of suspicion and conjecture surrounding their decisions. So now the people know what the reasons are. And mind you, a person may be a very good lawyer, but will not make a satisfactory judge. So these are all factors which the collegium takes into account, and when the reasons are given, then people don't think that this was on the basis of some secret conclave in amongst the collegium. It is a bit difficult. It would have repercussions on the persons who have not been selected, but I'm afraid that's the price we have to pay for transparency.
Okay. Satya Prakash, as far as this decision is concerned, do you believe that the Supreme Court has acted under pressure? Because there was a lot of, talk in the general public that, the judiciary should be far more transparent, the appointment system should be made far more transparent. Do you think that the Supreme Court has buckled under pressure?
Well, the decision is not what it looks like. Decision is basically to protect a status quo. It is not a revolutionary step as is being portrayed. Basically, they have protected the system. The system, that is the collegium system, was under attack for opacity. So they tried to give an impression that we have become transparent. They completely remain opaque in the sense they are disclosing the decision. Maybe there are reasons also. But those decisions would in any case would be made public by the government. Once somebody has been selected and appointed, you will get it as part of a government press release that so-and-so has been appointed as a judge of such and such High Court or the Supreme Court. So there is not the question of transparency. In transparency, I would have considered it if they had declared the criteria for selection of the judges, what are the eligibility criteria, what is the selection process, and how they are going to select it. Without doing that, if you just make public the decision and the reasons also, because the reasons have to be seen in the context of the criteria. In the absence of a clearly laid down criteria, the reasons would be, if I may say so, it will be whims and fancies of a judge or the collegium. And what is needed is institutionalized system where the criteria is pretty well known, process is pretty well known, and at what step, and there is also a need for shortlisted candidates, the names should be made public so that people, or at least whatever, maybe their institutional feedback, maybe the Bar Council of the state or the Bar Council of India can give feedback to the collegium. Maybe they don't make it public, but that will help the collegium to take a better decision, well-informed decision. In the absence of that, this, I don't say it goes much ahead. And the current system, the step is aimed at protecting the collegium system, which has been under attack from various quarters.
Okay. Just to widen the scope of the debate now, Justice Sodhi, what are your thoughts on the collegium system itself? Is this just being done to protect the collegium system as is being suggested by one of our speakers?
You see, as far as protecting the collegium system is concerned, this is the only system as far as of now which is working. Now, it was being accused of a lot of mishandling. The first step it seems to have taken at this time is because it was said that the collegium is very, very close. Collegium does not disclose its reasoning, does not disclose its mind. Therefore, they began by making the collegium a little more transparent. I believe there is a lot of room for improvement, and particularly, yes, I appreciate what Satya Prakash has said, that yes, the criteria for appointment itself has yet not been defined. And the reasoning without a criteria may not really stand its grounds. But however, give credit to the judiciary for opting to make itself available for criticism, if you may say, to its decisions. But at least it is opening up what was absolutely a closed house has now opened a few windows, and I'm sure over the course of time, everything, all these steps which we are all are demanding, and we've been saying it for a long time, will be put into practice, and I'm sure the system as it is can continue with changes. And if it does not work at all, then we can always have the other one, which we rejected.
Okay. Talking about the other one that we rejected, Mr. Sorabjee, is the debate between the collegium system and NJAC a closed chapter now? And do you believe we need a new system as far as appointing judges to the higher judiciary are concerned?
Look, I think the criteria are well known. Ability, integrity, and the proper temperament to deal with issues which come up before the courts. So I don't see any difficulty about the criteria not being there. Of course, how you apply them in a particular case depends on the facts of each case. But I think this makes, as they say, secrecy is a badge of fraud, sunlight is a good disinfectant, and this matter, this decision to make it public is a step in the right direction. It's not an ideal solution, but we remove all this atmosphere of rumor and conjecture as to why so-and-so was selected, why another person was selected. Of course, transparency doesn't mean you also disclose what Judge A told Judge B about a particular candidate, or Judge C told Judge D. Gist of the reasoning should be there, so people know that it's not done not by reason of caprice, not by reason of whim and fancy, but on some well-defined criteria. And as I said, criteria, of course, have to be there. Ability, integrity, and the right temperament to deal with issues which come before the court.
My other question to you, Mr. Sorabjee, do you believe that we need a new system to appoint judges to the higher judiciary?
No, I don't think so. The system is all right with a little modification and little changes as have been suggested. Which new system? Who is going to appoint? The executive? As I told you, it's not the best, it's not an ideal thing, but I don't think you require the system to be replaced by any other system, which means the executive decides who will be judges of the High Court and Supreme Court.
Okay, then I think I got my answer that the decision between collegium system and NJAC is a closed chapter at the moment. But, you know, Professor, as far as reforms, judicial reforms are concerned, where do we need to start and what needs to be done?
I would also say that now, after a national debate for a long time, we find that collegium system is convenient, and this is also more leaning towards independence, and we are able to trust the senior most judges of this country. But at the same time, as the apprehensions were about transparency and other things, I believe that that thing has to be looked into in a proper way, as I suggested earlier, and I may again say that if you are in a haste, then you can give the positive qualities, good merit of the judges who have been selected. Very objectively you can give, and others can themselves understand what that is not in others, rather than putting it that a judge gave a very good report about one and not about another person. That again remains very subjective. There is need for a very objective criterion, and that criterion has to be substantiated by very, very objective recommendations and findings. We have found these things. So that needs to be done, and that will be automatically becoming a very good procedure and a precedent, and that will give an understanding to all others that what is being considered. And that will remove subjectiveness from the system, because we would always say competence, good, that always remains a but once you select a judge, elevate a judge, you must mention that this was considered, this quality was considered, this merit was considered, and without that we will be in difficulty. But I'll again say that collegium system has come out as good, and it has I think it's more suitable.
Okay, it has its own merits.
But I will add one more thing here, that we will have to at some stage somewhere, if not appoint a judicial commission, but give better role to judicial academies. Judicial academies have to play a role, and I believe that they are not training the judges or having their sessions about improving their quality and competence. And there can be different kinds of evaluations also when they will attend different kinds of courses. Probably I'm saying this because I'm an academician that way. But I believe that there is definitely a need for that. And if even to the National Judicial Academy you will see, I don't know how the training is going on, who's training, who does it, what is the content, and what should be actually done, and what is the evaluation process there. And then even with a single report have they come that this was the course structure for a particular week for this kinds of judges, this was the lecture delivered by somebody. I think we have to look to that aspect also, because it can't come out of vacuum. It's not merely the evaluation in a very subjective way.
Okay. Satya Prakash, I saw you nodding, shaking your head when we were talking about the collegium system. So you don't agree with what the previous panelists said?
As many of the panelists have said, the collegium system is not the best system. NJSC perhaps would have been a much better system, but without testing it, they rejected it. Collegium system, the first and the foremost thing about collegium is that people of this country should know that collegium system is not a constitutional system, it is extra constitutional system. There is no provision for collegium in the constitution. The Supreme Court has created it. It is a judge-made law, and it was what is known as it was not a substantive judicial review. It was abstract judicial review. There was no law under challenge. All of a sudden, they created this system. So this kind of system is misuse of power of judicial review of the Supreme Court. That should not be done, and that you do arrogate all the powers to yourself, which is you are tinkering with the fine balance which is envisaged in the original constitution. You are giving all the powers to one particular organ of the government, and this is how you disturb the balance. This is a serious matter, and this tussle for power between the executive and the legislature on the one side and the judiciary on the other side, it started long back in 1973, the case 1 and Bharati case, and thereafter there have been too many cases. But on this issue, the last word is yet to be said. The government has lost it, but there are attempts to bring up the issue, and all the
so it's not a closed chapter, is what you're
relating
suggesting.
to memorandum of procedure, which is still pending. The government is saying something, the collegium is saying something, and to and fro, and whatever is happening. This issue is lingering on for almost 2 years, a memorandum of procedure, and that is because the government and the judiciary, the government, what they could not achieve through the NJSC, they are trying to achieve through the MOP, and the judiciary is still not, ceding ground. So this tussle is still on. It is not over.
Okay, the tussle between the executive and the judiciary is still on, and we might see something come up in the near future is what you're suggesting. But Justice Sodhi, taking the discussion forward now, as far as the judiciary is concerned, what do you think is the biggest challenge facing the Indian judiciary today?
To my mind, the judiciary is facing a challenge of credibility. You see, it has gone into negativity too much. The judiciary should never have come into focus in a negative manner as it is being projected all the time. I was against the collegium system always. But however, seeing that the present collegium system can itself be reformed to make it effective and can work properly, the independence of judiciary being primarily the main object, I think the main thing is to build up its own credibility. For that, this system of transparency, it has begun. I am not saying this is perfect as yet. There are lots and lots and lots of steps to be taken, which I am sure the judiciary in its own interest and in the interest of the people of this country is bound to take it, and these are not knee-jerk reactions, nor is the judiciary buckling under any pressure. No, it has taken a very serious and a very considered view that it should open up itself and make the public aware of how its judges are being selected and what are the criterias and what are their powers. Everything must be made absolutely transparent, so that the credibility and faith in the judge must never ever be shaken on any account.
Okay, sure. Mr. Sorabjee, we just spoke about the executive and judiciary and the tussle that has always existed between the two organs, but as far as government participation in judicial reforms is concerned, do you think that there has been adequate government participation in urgently needed judicial reforms?
But I don't know about government participation. I mean, who's the person who's best equipped to decide which lawyer or which judge should be elevated or appointed. Naturally, it's the collegium, it's the judges, and some amount of subjectivity will be there, but that can't be helped. But I think, as I said, this is not a perfect solution, and of course there can be reforms, there can be more transparency, but transparency not unlimited, not in the sense that you make clear the exact reasoning of different judges why a certain person was not elevated or was not chosen. It has to be worked in a reasonable, practical manner. And today, as things stand, as Justice Soli agree with him, credibility of the judiciary is most important. And today, with all the force of the judiciary, the common man, if there's any matter of public importance, they say we want a judge, sitting a retired judge of the High Court or Supreme Court to go into the matter. So that's important. That credibility must be mentioned, must be maintained. And that will be maintained when you know that these reasons are there, not reasons in the sense of detailed judgment, just gist of the reasons relevant, pertinent to the question of the appointment, the fitness of appointment of a particular person as a judge of the High Court or Supreme Court. And I think the collegium is best fitted to do that.
Okay, point taken. You know, Professor, do you believe that we need a systemic change as far as the judiciary is concerned? You know, we've spoken about several things. We've spoken about transparency. We've spoken about credibility. We've spoken about all these things. So do you believe, to bring all those things into the picture, do we need a systemic change?
I think, after all, behavior of the judge is important. And in our country, academia, that does not consider itself as the part of the system. That's why we don't have impact assessment of judgments. We don't have analysis of judgments. You can yourself see the law journals and law books otherwise. And at the same time, we are not having the studies which could look to the behavior of the judges. And it is needed too much. And that will bring out various kinds of basic things which are embedded somewhere, or people are not able to look to them. That is why I am saying that the academic community has to come forward, consider themselves as the part of the system, and then those things will come to light and people will start working on them. So the behavior of the judge,
stakeholders, is what you're suggesting.
Yes, case studies and behavior, and in many countries, and impact assessment. Judgments are coming, decisions are coming. What is the ultimate impact? That will assess the credibility then ultimately, what happened ultimately. So that part, I think it's totally missing, and it has to be taken that way.
You know, one aspect that we haven't spoken about at all is judicial infrastructure. Is there a need to rehaul our judicial infrastructure, Satya Prakash?
Of course, there is a need. Because in many parts of this country, the courts, they don't have proper infrastructure, even the basic building or furniture they don't have, electricity supply. So it's a huge problem, and the government is trying to do it given the crunch of resources. But in many cases, the central government is funding the states for creating court infrastructure, and there is a PIL pending in the Supreme Court. Supreme Court itself is monitoring the progress regarding court infrastructure. And the latest is now there is, the government and the court, they have joined hands together and they are going for e-court projects. So if entire court system is, computerized and connected with each other, many of the problems relating to delay can be solved because of the technological advancement, and if they make use of information technology in courts, that can be done.
Okay, I've got 1 minute left on the program. Quick closing comments from Mr. Sorabjee and Justice Sodhi. Justice Sodhi, what's the way forward as far as the Indian judiciary is concerned?
Well, we must keep changing. We must be aware of the nature of changes that are necessary and adopt them as quickly as possible without being accused of buckling under pressures or knee-jerk reactions. Nothing of that sort. The judiciary has done a good job, and I'm sure it is capable of taking care of itself.
Okay, Mr. Sorabjee.
Independence, very important.
Sure. Mr. Sorabjee, close the show for us with your concluding remarks.
Well, we must maintain the independence of the judiciary, and we must realize that judges are equally interested in the appointment of right kind of persons to the High Court and the Supreme Court. They have no vested interest in this. The only interest is effective administration of justice by people who will be asked to protect and enlarge the fundamental rights of the people. That's the one criterion which should be always kept in mind. Of course, judges not being divine, they're fallible beings, but they should not be forgotten, and they should not be minimized, because in some cases you will say, oh, this man was wrongly overlooked, or the person appointed is not the correct person.
All right. On that note, then, we'll have to call it a wrap on this edition of The Big Picture. I'd like to thank all my guests for joining me on the program and putting things into perspective for us. That's all the time we have today. See you again next time.